How do we work with documents that we've received in written discovery or by subpoenas when we take depositions or when we question somebody at the time of trial? It's a little bit tricky under the California Evidence Code because documents speak for themselves. In other words, you don't need a person to tell you what a document says because you can look directly at the document and the document already says it. We see younger lawyers, and some older lawyers too, but we see lawyers making the mistake in deposition where they'll hand the deponent, usually our client, a copy of a document and say, you see that warning right there in that prospectus about investing in this particular asset? Do you see that warning? And the client says, yes. Do you see where it says warning? Yes. It says warning, right? Well, that's the classic example of the document speaks for itself. The document already says warning on it. The proper way to use this document would be to ask the trustee, have you ever seen this document? And if the trustee says, yes, I saw that document. Did you read that document? Yes. And then you could say, I'm clear and I understand, then you understood that there were risks involved in investing in this particular asset. And the trustee should say yes. And you saw this where it says, warning, this is a speculative asset. You saw that language before you invested in the particular investment, and the trustee would then be required to say yes. Notice that I didn't ask the trustee at any point in time to confirm to me that the document said, warning, this is a dangerous speculative investment. But yet I was able to get the trustee to confirm with me that in fact they had read that it was a warning, it was a dangerous asset or a speculative asset to invest in, and that's how I can use the document in the deposition and then at the time of trial to introduce evidence